It's lovely to be here, and thank you for coming, and I hope you find what I have to say interesting, and maybe you might want to challenge me on some of it, so that'll be good too. I ought to confess that I gave a lecture on this subject to the Oxford Centre for Islamic Studies earlier this year, but there is a precedent for my repeating at the Woolf Institute a lecture which I gave to the Oxford Centre for Islamic Studies, because some years ago I gave one on religious dress, and so I'm doing the same thing again. So, two for the price of one, yes. And I'm talking about religious rights and freedom of speech. And the relationship between the two is complicated and emotive, but it's one in which I am proud to have made a small contribution, as the following history will relate. Gay News was a fortnightly newspaper which ran from 1972 to 1983. In June 1976, it published a poem by Professor James Kirkup called "The Love That Dares to Speak Its Name." It's not a very good poem, but it does pack a certain punch. It tells of the passionate love felt for Christ by the Roman centurion who lifted him down from the cross after his crucifixion. It gives a graphic description of homosexual sex acts between the centurion and the dead body. It claims that Christ had had sex with numerous other biblical figures, including John the Baptist and all 12 of the apostles, and even more implausibly, Paul of Tarsus. And perhaps the most shocking of all, it claims that the risen Christ appeared to the centurion first on the third day. From this brief description, it will be apparent that the poem was not questioning the divinity of Christ or his resurrection from the dead, which are the central tenets of the Christian faith, but it was deeply shocking to many Christians, partly, no doubt, because of its description of homosexual acts, and partly because it alleged that Christ himself was gay. The editor, Dennis Lemon, and the publisher of Gay News were prosecuted for the common law offence of blasphemous libel. Blasphemy, the spoken word, and blasphemous libel, the written word, were recognised as offences in English secular law in the course of the 17th century, having previously been punished only in the ecclesiastical courts. Chief Justice Hale, no relation, I have to say that for various other things that Hale did, but he was a great man. Anyway, he justified this because the Church of England was established by law and thus, quote, part and parcel of the laws of England. During the 19th century, however, it was established that it was not blasphemy to promote atheism or agnosticism, or indeed other religions, or even to attack Christianity and the established church, provided that this was done in a moderate and decent fashion. The textbook definition of blasphemy, this is in Stephen's Digest of the Criminal Law, was publishing, quote, any contemptuous, reviling, scurrilous or ludicrous matter relating to God, Jesus Christ, or the Bible, or the formularies of the Church of England as by law established, end quote. So it was not unlawful to leave money by will to the National Secular Society, whose main object was to promote the principle that human conduct should be based on natural knowledge and not on supernatural belief, because the mere denial of Christianity without scurrility or profanity was not blasphemous. And by 1976, when the Kirkup poem was published, it was thought that the offence had become obsolete. There had been no prosecution since 1922, so that's more than 50 years. The Gay News prosecution was brought not by the state prosecuting authorities, but by Mary Whitehouse. Some of the people in this room will remember Mary Whitehouse, a prominent private citizen who had founded the National Viewers and Listeners Association to campaign against bad language on the BBC, and was a vocal opponent of the permissive society generally. The trial judge directed the jury that it was sufficient if they took the view that the poem vilified Christ in his life and crucifixion, and that the defendants intended to publish it. The prosecution did not have to show that they intended to attack the Christian religion or to insult or outrage Christian sympathisers or believers, or to provoke a breach of the peace. The jury convicted both defendants by a majority of 10-2. So the 10 must have concluded that the poem was blasphemous. The publishers were fined £1,000, and the editor was not only fined £500, but given a sentence of 9 months' imprisonment, albeit suspended for 18 months. It's interesting that it was the editor and the publisher, rather than the author of the said poem, who were prosecuted. The Court of Appeal rejected the defendant's argument that it was necessary to prove an intention to blaspheme, and that Dennis Lemon should have been allowed to give evidence about his intentions in publishing the poem. But they did quash the suspended sentence. It then went to the House of Lords, which was then the highest court in the land, and they also rejected the argument that it was necessary to prove an intention to blaspheme, albeit by a majority of only 3-2. Their lordships recognised that the point was not entirely clear and needed clarification, so they clarified it the wrong way, obviously. It's a tendency we have. One of the majority was Lord Scarman, who is generally regarded as a liberal-minded judge, and he commented that in an increasingly plural society, such as that of modern Britain, it is necessary not only to respect the differing religious beliefs, feelings and practices of all, but also to protect them from scurrility, vilification, ridicule and contempt. But of course, blasphemy and blasphemous libel protected only Christianity and indeed especially the Church of England. Now, the Law Commission had been set up by statute in 1965 as a public body with a mission to simplify and modernise the law. And among its first tasks was to codify the criminal law. The continued existence of offences defined not by Parliament but by judge-made law was inconsistent with this aim. So the Commission set about reviewing each of the remaining common law offences, including blasphemy. And in 1981, nearly 2 years after the House of Lords' decision in the Gay News case, the Commission published a working paper, it's a consultation paper, on offences against religion and public worship. It's important to mention who the members were at that stage. They were Mr. Justice Kerr, the chairman, Dr. Stephen Cretney, an academic, Stephen Adele, a solicitor, William Forbes, Queen's Counsel, and Dr. Peter North, another academic. You see, the whole idea of the Commission was that it would have 5 very distinguished lawyers from different walks of legal life. So if they could all agree on something, the odds were that it was the right thing to do. That's the theory behind the Law Commission. And the premise of the working paper was that the common law offences should be abolished, and the question was what, if anything, should replace them. In today's plural society, any replacement would have to apply to all religions and not just Christianity, as Lord Scarman had suggested. The Commission reviewed the reasons for having such an offence and discovered 4: the protection of religion and religious beliefs, the protection of society, the protection of individuals' feelings, and the protection of public order. And it concluded that the protection of religious feelings, that's the third, was the most persuasive, but the arguments were quite evenly balanced. There was no evidence of a pressing social need for an offence, of wounding or outraging religious feelings. It would be very difficult to define its elements with sufficient precision. In particular, it would be very difficult to define what was meant by a religion. That's your exam question for today. Yeah. The Commission therefore reached the provisional conclusion that the offences should be abolished without any replacement. The working paper provoked a huge response. 1,800 organisations, groups and individuals, more than 175 petitions with a total of nearly 12,000 signatures, many in response to organised campaigns. This is much greater than any of the other working papers which the Commission had published. Respondents were overwhelmingly against the provisional proposal. of abolition without replacement. But of those who were clearly responding to the working paper rather than to reports in the media, how many people actually read Law Commission working papers? They are very long. So people who'd actually responded properly, opinion within the churches was generally against abolition without replacement, and opinion within the legal profession and academics was generally in favour of abolition without replacement. The Church of England was in favour of a replacement which would extend to all religions. Interestingly, well, to me at least, while most of the main religious Christian, Jewish and Islamic organisations responded, the Hindus, Sikhs and Buddhists did not, which I think says something about those different faiths. When the Commission came to consider what to make of all of this, its membership had changed. Mr. Justice Kerr and William Forbes QC were replaced by Mr. Justice Ralph Gibson and Brian Davenport QC. Davenport QC was in charge of the criminal law team. The new Commission decided that it would recommend a new offence of injuring religious feelings, which would apply to members of all religions without defining what was meant by a religion. The obvious risk of excessive prosecutorial zeal would be met by requiring the Director of Public Prosecutions or the Attorney General to consent to a prosecution. So a report was drafted to this effect. But it was then the practice for all Law Commission reports to be accompanied by a draft bill to give effect to its recommendations. That's a really useful discipline. It's one thing to say, oh, this is a good idea for making the law better. It's an absolutely different thing to draft a bill which has a chance of getting through Parliament to implement that recommendation. So it's a very useful discipline. So the report had to wait until the parliamentary drafters attached to the Commission had got time to draft a bill. They dragged their feet. It was clear that they didn't relish the task, and who can blame them? And that was how things stood in May 1984, when, as you have been told, I joined the Commission. Stephen Adele and Stephen Cretney left, and they were replaced by me and Professor Julian Farrand. We were not then man and wife. That was sometime in the very distant future. So, one of the first things to hit our desks was the Blasphemy Project. Now, Professor Farrand was a lifelong atheist, a member of the National Secular Society. So it was not surprising that he immediately voiced his doubts about the proposal. Mrs. Hoggart, as I then was and is a not very practising member of the Church of England. So it was perhaps more surprising that she voiced her strong opposition to it, much stronger than Julian's. Dr. North was due to leave the Commission shortly, so it was decided to wait and see what his replacement would say. Trevor Aldridge, a solicitor, arrived in September, and he very soon allied himself with Farrand and Hoggart. So what had been a unanimous report in favour of abolition with replacement, with this strange offence, became a 3-2 report in favour of abolition without replacement, with the dissenters saying there should be replacement. The resulting report, with an accompanying bill and a note of dissent, was published in 1985. Of course, nothing was going to come of it. What government was going to risk alienating its supporters, both in and out of Parliament, by trying to abolish blasphemy? But never say never in law reform. There are some reforms whose time will come. And the time came in 2008. Section 79 of the Criminal Justice and Immigration Act 2008 abolished the crimes of blasphemy and blasphemous libel. The National Secular Society held a bye-bye blasphemy party to which Julian and I were invited. By then we were man and wife. So Ian McKellen read the poem, which is why I know it wasn't very good. So never say never, its time had come. But I must go back to the Law Commission's 1985 report, because the seeds of why its time did eventually come were sown in that report. It's also a very useful discussion of the arguments for and against having a criminal offence of blasphemy. The first rationale given for such an offence was the protection of religion and religious beliefs, and this was regarded by the large majority of respondents to the working paper as the strongest reason for retaining it, most of them referring to the Christian religion alone. The problem with protecting religion and religious beliefs by law is that it can only really apply to the protection of the God of one faith. It's quite rational for a state which has a state religion to protect that religion, whether Judaism in Israel or Islam in Bangladesh. Indeed, that appears to have been a reason for recognising the secular offence in this country. But although we still have an established church in England, though not in Scotland, Wales or Northern Ireland, this no longer means that everyone has to belong to it. It's no longer the policy of our law to assert the truth of any particular religion by means of the criminal law. Indeed, we assert the right of everyone to hold and manifest their own religion or belief, including the belief that there is no God or gods. Indeed, it could even be argued that it's not very Christian to assume that our God is in need of special protection or to oblige the unwilling to respect him. So, I think that puts paid to the protection of religion and religious beliefs. Second rationale was the protection of society. Attacking religion, it was said, by the Times on the 13th of July 1977, amounts to an attack upon the fundamental decencies and mutual respect on which society operates and could damage the stability of a community. Allowing total freedom to insult the religious beliefs of others can also have a profoundly adverse effect on the harmony that exists between different groups, particularly, perhaps, where racial and religious divisions go together. The problem with this argument is that everyone agreed that no harm is done by rational and sober, as distinct from scurrilous or abusive treatment of religious matters. Yet it is quite possible that a work of serious literature can induce outrage among some people. We only have to think of Salman Rushdie's Satanic Verses as an example of that. And rational discussion may be much more persuasive and destructive than scurrilous abuse. In fact, it usually is. And thus induce much stronger feelings in response. I mean, we all know how infuriating it is to have our deepest beliefs destroyed by rational argument. This is much more infuriating than having them abused. So, as the working paper said, if society would suffer as a result of an absence of respect shown to religious beliefs, it may be suggested that it will suffer all the more if such beliefs are subject to destructive analysis and criticism, even if temperately expressed, since reason's persuasion is ultimately far more effective in its aim than attacks devoid of intellectual content. So can it really be said that it's damaging to society to be rude about religion, but not damaging to society to undermine religion by reasoned argument? So this begins to look more and more like the first argument, the need to protect religion, which begs the question of which religion? In any event, as the Commission pointed out, the distinction between manner and matter is probably unsustainable. Ridicule has for a long time been an acceptable means of focusing attention upon a particular aspect of religious practice or dogma, which its opponents regard as offending against the wider interests of society. And one person's incisive comment, or indeed seemingly innocent comment, may be another's blasphemy. And some religious practices are not in the best interests of society and deserve condemnation. As Professor J.C. Smith, the great expert in the criminal law, academic expert in criminal law during my lifetime, commented in response to the Gay News case, should it not be possible to attack in the strongest possible terms religious beliefs that adulterers should be stoned to death and that thieves should have the offending hand lopped off, however offensive that may be to the holders of that belief? He asked the question. Finally, on this point, the Commission suggested that the existence of a criminal offence for which there was little or no justification, and indeed good reason not to impose criminal sanctions, as it affects the sensitive area of freedom of speech, might itself be a source of conflict. I think we can all think of examples where the existence of criminal offences has caused more trouble than it's worth. A third rationale was the protection of religious feelings. In the working paper, the Commission had thought this the most persuasive argument, although by no means decisive. Yet the law doesn't generally impose criminal penalties for injuring a person's feelings. So the argument must depend upon the notion that religious feelings are different from any other kind of feelings and worthy of special respect. And of course, many religious believers do indeed believe this. The working paper had suggested that such feelings might be different because of the special reverence felt for what is deemed sacred. But is such reverence special in nature or degree? If it is thought special only in degree, that is its depth or its extent, then what is the evidence for this? Many people feel equally strongly about all sorts of things, including the lack of religion, but they're not protected from being upset. If it's thought special in kind, that is in nature, then again, what is the evidence for this? Is there any real difference between reverence for a deity and other kinds of reverence? For example, for your country, your monarch, your national flag, or more plausibly, your football team, or your parents. Contempt for any of these might be thought just as deplorable as contempt for a deity. But we can't extend the criminal law to protect all these sorts of feelings. This would be a serious interference with freedom of speech. Reverence for a deity may differ in degree from reverence for other sorts of beings or institutions, but it doesn't differ from them in kind. And so the final rationale was the protection of public order. Now, we all know that the expression of beliefs about religion, for or against, general or particular, can arouse strong feelings which can escalate into public disorder and worse. Only last September, hundreds of young men fought one another and the police over 2 nights in Leicester, all said to be sparked by the anti-Islamic policies of the BJP in India. But we have the Public Order Act to deal with that. It now penalises threatening, abusive or insulting words or behaviour, or the display of any writing, sign or other visual representation which is likely to cause harassment, alarm or distress. Is there any evidence that purely private attacks upon religion are likely to lead to public disorder? So the Law Commission report rejected all of those arguments, and it made an important distinction between attacks upon a religion and attacks upon the people who hold its beliefs. Indeed, were the Leicester riots sparked by BJP's attacks on Islam or by its demonisation of Muslims and other minority groups? The offence of blasphemy is aimed at attacks on religion, not at attacks on people who hold particular religious beliefs. And back in 1985, the Law Commission pointed out that there were already offences of intentionally stirring up racial hatred, introduced by the Race Relations Act 1976, in response to a known problem of hostility towards racial minorities. And it observed that if in future there appears to be a substantial problem relating to the availability of material which in form is an attack upon particular religious beliefs, but is in substance an attack upon those holding such beliefs, it would seem to be a relatively simple matter to amend the Public Order Act specifically to penalise such material. And that's what came to pass. The Racial and Religious Hatred Act of 2006 added a new part to the Public Order Act 1986, creating offences of intentionally stirring up religious hatred in a variety of ways, using threatening words or behaviour, displaying, publishing or distributing threatening written material, presenting or directing a play which involves the use of threatening words or behaviour, displaying, showing or playing a recording or threatening visual images or sounds, broadcasting a programme involving threatening visual images or sound, or possessing such material with a view to doing any of these things. So, all of them require an intention to stir up religious hatred, meaning hatred towards a group of persons defined by reference to religious belief or lack of religious belief. Now this is, as the Law Commission pointed out, a much more defensible approach because it's protecting the people rather than the beliefs as such. Even this can be regarded by bodies such as Index on Censorship as an unwarranted interference with freedom of speech. And the concepts of hatred and stirring up could be sufficiently elastic to catch a good deal of behaviour, so they need to be pretty tightly interpreted. Be that as it may, the introduction of these offences meant that blasphemy and blasphemous libel were no longer needed, and so 2 years later they were abolished. I think that's pretty prescient of the Law Commission to have pointed out the defensible offence is the one of stirring up hatred against the holders of beliefs, and when it eventually happened, then the time had come to stop having blasphemy and blasphemous libel. It's striking that the Law Commission's 1985 report says very little about the European Convention on Human Rights. The UK was an early party to the Convention and accepted the right of individual petition to the European Court of Human Rights in 1966. But the Convention only gets a mention in a footnote, because Gay News and Dennis Lemon tried to take the United Kingdom to the European Court of Human Rights for breach of their Convention rights. They claimed in particular a violation of Article 10, which is the right to freedom of expression. Forgive me, many of you will know it off by heart, but I'd better read it out just in case you've forgotten it. Yeah. 1. Everyone has the right to freedom of expression. This right shall include the freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. It's a bit more. 2. The exercise of these freedoms, since it carries with it duties and responsibilities, may be subject to such formalities, conditions, restrictions or penalties as are prescribed by law and are necessary in a democratic society. These are two very important phrases in the European Convention: prescribed by law and necessary in a democratic society, in the interests of national security, territorial integrity or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, for preventing the disclosure of information received in confidence, and guess what the last one is, for maintaining the authority and impartiality of the judiciary. We're really grateful to them for having that in. Yeah. There is still, but we've largely abolished it, an offence which in Scotland is known as murmuring judges. But it's basically being rude about the judges. Well, our backs are broad. Anyway. Now, in those days, complaints to the Strasbourg Court had first to be scrutinised by the European Commission on Human Rights. And the UK government, in the case of Gay News and Lemon against the United Kingdom, no doubt drawing upon the Law Commission report, argued that restricting free speech by the offence of blasphemy was justified for the prevention of disorder, the protection of morals, and the protection of the rights of others. Those are three of the possible justifications. The European Commission pointed out that this was a private prosecution, so it couldn't be said that the public interest in the prevention of disorder or the protection of morals was the real basis for the interference. That's a very clever point, wasn't it? You wouldn't have thought of that, would you? No, I don't think I would have done. The real basis must have been the protection of the rights of Mary Whitehouse. But the Commission considered that the protection of the right of citizens not to be offended in their religious feelings was a legitimate purpose recognised in the Convention. So they went the other way from the way the Law Commission had gone. And the European Commission also concluded that the restriction was necessary in a democratic society. If it is accepted that the religious feelings of the citizen may deserve protection against indecent attacks on the matters held sacred by him, then it can also be considered as necessary in a democratic society to stipulate that such attacks, if they attain a certain level of severity, shall constitute a criminal offence, triable at the request of the offended person. It wasn't disproportionate for the offence to be one of strict liability, irrespective of the intention to blaspheme, the intended audience, and the possible avoidability of the publication by the person offended. Mary Whitehouse did not have to read gay news, did she? Well, there we go. So that was what the European Court of Human Rights was saying. Now, they found the complaint manifestly without foundation, as were other complaints based on certain other articles. So, the European Court of Human Rights apparently continues to believe that the protection of religious feelings is a legitimate aim. And the first case that came on the court on this was a case called Wingrove in the United Kingdom. And this was brought because the applicant's video, called Visions of Ecstasy, was refused a classification certificate by the British Board of Film Classification, without which it was a crime to show the film. Now, when I describe the film, you may think it would be a crime to show it, but not for that reason. It depicted a woman in a nun's habit, apparently having sex with the crucified Jesus. There seems to be some sort of theme here, doesn't it? So it's perhaps scarcely surprising that it infringed the criminal law of blasphemy. The European Court held by 7 votes to 2 that there was no violation of Article 10. Protecting Christians from outrage fell within the legitimate aim of protecting the rights of others. So that was back in 1996. But more recently, in a case called ES against Austria in 2018, the court held that convicting the complainant of blasphemy did not violate her Article 10 rights. In a seminar about Islam, she had referred to the fact that at the age of 56, the Prophet Muhammad had married a 6-year-old girl and had consummated the union when she was aged 9. And ES commented, quote, "What do we call it if it is not paedophilia?" End quote. So she was prosecuted for blasphemy. The European Court held that the purpose of the law was preventing disorder by protecting religious peace, as well as protecting religious feelings, which corresponds to protecting the rights of others. In assessing whether the restriction was necessary in a democratic society, the national authorities enjoyed a wide margin of appreciation and also had a positive obligation under Article 9 of the Convention of ensuring the peaceful coexistence of all religions and of those not belonging to a religious group by ensuring mutual tolerance. They held that the national court, the Austrian court, had carefully balanced the applicant's right to freedom of expression with the rights of others to have their religious feelings protected and to have religious peace preserved in Austrian society. So that's not only religious feelings, it's introducing a public order element into it. So that was a view expressed by the European Court of Human Rights. But it is interesting that most international instruments draw the distinction which English law now draws between injury to religious feelings and stirring up religious hatred. So the Council of Europe Parliamentary Assembly in 2007 recommended that blasphemy as an insult to religion should not be deemed a criminal offence. The European Commission on Democracy Through Law, the Venice Commission, in 2008 stated that it is neither necessary nor desirable to create an offence of religious insult, that is, insult to religious feelings, simpliciter, without the element of incitement to hatred as an essential component. The United Nations Human Rights Committee in 2011 commented that prohibition of displays of lack of respect for a religion or other belief system, including blasphemy laws, are incompatible with the Covenant, that means the International Covenant on Civil and Political Rights, except in the specific circumstances envisaged in Article 22, which is advocacy of religious hatred that constitutes incitement to discrimination, hostility or violence. And the European Parliament in 2012 recalled that national laws that criminalise blasphemy restrict freedom of expression concerning religious or other beliefs, that they are often applied to persecute, mistreat or intimidate persons belonging to religious or other minorities, and that they can have a serious inhibiting effect upon freedom of expression and on freedom of religion or belief, and recommends that member states decriminalise such offences. So that's the European Parliament. So I'll end with a member state, perhaps a surprising one, which has recently done just that. And this is the Republic of Ireland. Now, being a country almost defined by the predominant religion of its people, the Roman Catholic faith, its 1937 constitution required it to criminalise the publication or utterance of blasphemous matter. It undoubtedly meant Christian attacks on Christianity. It was thought that the inherited English common law of blasphemy did just that. But in 2009, the Irish Defamation Act created a statutory offence which criminalised the publication or utterance of blasphemous matter defamatory of any religion. So they'd obviously taken the point, you can't just protect Christianity. Not long after that, respect for the Roman Catholic Church in the Republic of Ireland, I wrote here collapsed. I think that's putting it a bit strongly, but seriously diminished. And the mood in Ireland radically changed. And in 2018, a referendum on amending the constitution to remove the requirement to criminalise blasphemy was supported by nearly 65% of the people voting. And in 2020, the law was repealed. Interestingly, to me at least, the amendment had the support of all political parties and many other organisations. The Irish Catholic Bishops' Conference did not oppose it, observing that the law was obsolete and that similar laws had been used elsewhere in the world to justify violence and oppression against minorities. The Islamic Cultural Centre of Ireland was among the very few organisations to oppose it. Now, I'm all for promoting religious peace and toleration. I can certainly live with criminalising the intentional stirring up of religious hatred, provided that the strong word hatred is not watered down too much. But I'm not in favour of punishing those who offend religious feelings. In a pluralistic and tolerant society, we ought all to be able to cope with having even our deepest feelings offended. And I remain unconvinced that religious feelings necessarily differ in depth or in kind from many other feelings. Thank you.